to need to not provide this contact information and names of their witnesses in early May of this year. June, July, August, September, October, November. That's like 6 months. But it took until October 17th for them to finally file their motion. For months, it was impossible for the defense to properly investigate the allegations against Kevin. Time was wasted as only one side had access to the most important evidence in the case, the eyewitnesses. In every court appearance in which this issue was discussed, the defense, me, said the same thing. Turn the contact information and names to just the lawyers, and we won't share them with Kevin or anyone associated with him. How else can we defend them at trial if we can't speak to them or at least investigate them? In this way, by saying that we would take the information ourselves and not pass it to the defendant or his family, we're basically alleviating the prosecutor's concerns. We're not going to share the information. The judge who was in place at the time, Judge Jackson, she reacted positively to that middle ground compromise that we made. As I said, we weren't insisting that we get the names and contact information with no limitation. But they never filed the motion. There was always one excuse after another. They weren't ready with it. The prosecutors pointed to no effort by Kevin to contact any witnesses in the case, to obstruct justice by threatening or intimidating any witness in this case. Instead, they speak to him or at least investigate them. Instead, they claim that he's dangerous, that he's in a gang, and that they claim that the case is so high profile, as they noted in their papers, that surveillance video from the crime, because it happened on the street and there's a lot of cameras all over the place on the street, that surveillance video had been posted to YouTube, and that some anonymous YouTube comment and anonymous people in the courtroom had taken pictures of what happened in court and posted them on social media. Who's to say any of this had to do with Kevin? There's all kinds of people that come to court. And as I said, one YouTuber posted a video containing a copy of the defendant's arrest warrant, and included in the part was an officer identified, who identified the defendant in the surveillance video. And the title of the video named the officer and stated that he would be, quote, a major witness in a murder trial. And as a result, the officer expressed to the DA's office that he had concerns about his safety. I can understand that. The question that jumps out is, what does it have to do with the prosecutor simply providing the witness information just to defense lawyers? Unknown people took pictures in court. Unknown people pointed out that someone in a video was a witness in the case. So that means the defendant doesn't get to investigate the charges against them, which could land him in jail for life. All of this evidence, the names and contact information of witnesses, is discoverable by statute to the defendant. The statute requires us to get it. The prosecutor can then move to deny access to this evidence if they make a showing of good cause to the court. And sure enough, good cause can include, according to the statute, and I'm quoting, danger to the integrity of physical evidence or the safety of a witness, risk of intimidation, harassment, or unjustified annoyance or embarrassment to any person, and the nature, severity, and likelihood of that risk. Likelihood of that risk. And in making this determination, courts can weigh, quote, the nature and circumstances of the factual allegations in the case, whether the defendant has a history of witness intimidation or tampering, and the nature of that history. Now, we would argue that there is no evidence that Kevin has a history of witness intimidation or tampering with evidence. But the law also states that when weighing these factors in determining whether a protective order can be granted, the court must engage in a discretionary balancing test of all these factors. And even if the court finds that good cause does exist to issue a protective order, the statute makes clear that the court should consider what can be done to remove any of the prosecutor's concerns about their witnesses. And that's what's written into the law. And I'm going to read it to you. This is what's in the law. The court may impose as a condition on the discovery to a defendant that the material or information to be discovered be available only to counsel for the defendant, or alternatively, counsel for the defendant and persons employed by the attorney to assist in the preparation of a defendant's case. They may not disclose physical copies of the discoverable documents to a defendant or to anyone else. That's what the law says. That's exactly what we've been proposing since May, when we first learned of the prosecutor's desire to not turn over the names of the witnesses. Somehow, some way, in their 30-page memo of law, not once did they even comment on this middle ground that they know that we've proposed, that we get the information ourselves and not the defendant? Naturally, we heavily hit this in our response, which was filed this past week. And in order to make it better for us, I suppose, this is what's in the law. The court may impose as a condition on the discovery to a defendant that the material or information to be discovered be available only to counsel for the defendant, or alternatively, counsel for the defendant and persons employed by the attorney to assist in the preparation of the defendant's case. They may not disclose physical copies of the discoverable documents to a defendant or to anyone else. That's what the law says. That's to try to alleviate the prejudice against us. The prosecutors mentioned in their papers that they were unaware of any information regarding the witnesses which are exculpatory, meaning that's either helpful to the defendant or impeaches some of their witnesses, which makes them less believable. And I found this argument particularly bizarre because if you ask a prosecutor if they think there's any evidence in any of their cases which is helpful to the defendant, they'll tell you, of course not. They're guilty of everything. They're hardly the proper people to know what I, the defense lawyer, considers to be helpful in defending a criminal defendant, mainly because they've never defended anyone before and I've only done it 1,000 times. All of this will be decided on November 16th. I'll give you an update when that happens. It's a little over a week. And now that we have a judge who is not retiring, I suspect this case will move along faster. And Kevin Perez will have his day in court. And this is a client that I've grown to really like. I've grown to really like his mother, his managers. These are decent people to try to alleviate